Members, good morning. This is the Bills Committee on District Council's Amendment Bill 2013. This is the second meeting. I call the meeting to order. We have a quorum and this is the appointed time. Let's invite the administration to join us. Item number 1 is meeting with the deputations, meeting with the administration. We have with us the Undersecretary for Constitutional Amending Affairs, Mr. Lau Kong-wah. Sorry, it was a mouthful. And Principal Assistant Secretary Ms. N. Tang, Senior Government Counsel Ms. Emma Wong, and Government Counsel Mr. Henry Chan. This bill is very simple. I will defer to the Undersecretary to explain to us the bill. This bill seeks to abolish the appointed seats in the District Council. If it's approved by the Legislative or the Bills Committee, then it will take effect on the 1st of January 2016. We need to amend, we need to appeal the relevant provisions that refers to the appointment of DC seats. Members mentioned about ex-officio seats, but we are not going to deal with it here. But we were asked whether the number of directly elected seats will increase as a result of the abolition of the appointed seats. And we will take on the relevant work. We asked the Bills Committee to remove all references to the appointed seats in the relevant ordinances. Thank you, Undersecretary. Now, this is rather technical and of a narrow scope. Well, this in effect is to abolish all appointed seats. If we all have the same focus, or perhaps we have different areas of concern, we can discuss them one by one, and then we will move on to the clause by clause. On the 9th of April, there will be another meeting. It will be a public hearing. For us to hear the views of the public. There are many people who have given an indication that they would like to express their views. So far, 5 individuals and deputations. And we don't think the next meeting will be long. This is for your information. If you have no objections to the approach I've just suggested, Then I give the floor for members to express their views. Mr. Christopher Chung. Thank you, Chairman. The abolition of appointed seats. Well, as a result of the abolition, will it result in too few a number of DC members in a certain district or constituency? Are there any regulations on the number of DC members? And if it falls below this number as a result of the abolition, what can the administration do? Will the constituency be combined, or will the number of seats be reallocated? Mr. Leung Chi Chan, you are just expressing your views. Yes. Should I go ahead? I just want to know about your areas of concern. And similarly, I support the abolition of the appointment system. The DC comprises of three types of members: ex officio, appointed, and directly elected members. What is the difference between ex officio members and appointed members? The ex officio systems are appointed by the administration on the strength of certain provisions. And isn't it something similar to appointed seats? Yes. Just tell other members, just tell me what you're concerned with. There may be others. Well, there are two issues. First, with the abolition of the appointment system, whether it will affect the minimum number, if any, of the DC, and the impact on district councils. And the second issue is about ex officio members and appointed members. Mr. Christopher Chung, do you have anything else to say? I will let the Undersecretary speak first. Undersecretary. Yes, there is a certain ratio between number of members and population. There will be one DC members to about 17,000 people, but there is no rules on the exact number of DC members in a certain constituency. The number of DC members depends on the level of population. Of course, for some administrative districts, there may be more DC seats than others. Mr. Chung asked whether there will be any adjustments in the future as a result. Of course, this involves the geographical factors such as the geographical delineation of the districts and whether the constituents are familiar with the area. If members are interested, we will put forward this issue for discussion. We will listen to members' views and views of the public. Mr. Chung, I think it is related because we're elected and we'll have to listen to the views of our constituents. And it is the constituents identify with the members in the constituency. And there is also the issue of integrity. If there is a drop in number, will it affect my constituency? And it may affect me. I may not find it acceptable. I think it is better to leave it. You say that the administrative district doesn't require an exact number or a minimum number. I think before you introduce any changes, you will have to take into consideration the acceptance of the public. So it is related. I understand. I do think that you will have to take into consideration the operation of the district with the abolition. Say, for example, in Wan Chai, that when there is a change, it will have an impact on the operation of the council. They deal with a large number of areas, leisure, recreational, transport, traffic. DC members collect views from the public and follow these issues up in the council. If there are too few members, it will obviously affect the operation of the council. And of course, the same goes for an excessive number of members. But it's not like Legislative meetings when members can attend meetings from the start of the day till late at night and then only to begin the next morning. You have to consider the number of DC members. What is the optimum number in a DC? These are not just issues raised in Legislative. You will have to discuss all the different issues. Mr. Christopher Chung. Well, I don't agree with you. And a large number doesn't mean that it is inefficient. I have been a councillor for many years, and our efficiency has been excellent. For the Eastern District, if we don't have a sizable venue, and if there are any changes, we won't even have a venue to organize activities. You've heard it, right? Yes. Any other views on this point? No? Mr. Leung Chi-Chang? About the second issue, ex officio members and appointed members. I mentioned about ex officio members. Chairman, you just said that we're not here to discuss that. But I do think that we do have to look into the definition of ex officio members. The three types: directly elected, ex officio members, and appointed members. And when you abolish the appointment system, then it blurs the definition of ex officio members, because we will only have two types of members. Ex officio members are actually elected members. It's just that it is indirectly elected. So is ex officio still an appropriate nomenclature for this type of members? So do they still have to be appointed by the administration? So please explain what is an ex officio member.
So the question is whether the ex officio members are appointed ones. It's clear that they are not, and they do not need the appointment of the administration. There are regulations. There is regulation regulating them, and they are known as ex officio members. After the abolition of the appointed seats, will we see a change of name of ex officio members? Should they still exist? And some members think we should keep them. Now, we have discussed these matters in the past. After the bill has been passed, I'm sure the above matters will still be discussed at Legislative. So my answer to the question is ex officio members are not appointed district councillors, and the bill does not deal with the ex officio members. Under Secretary, the amendment focuses on the abolition of appointed seats. But how can you tell me the ex officio members who come from elections will still be called ex officio members? So I think they should be changed to members elected indirectly. Then it will be clearer. Ex officio members are different from the appointed ones because they came up after from indirect elections. Well, if you call these people appointed members, then those who come from direct elections are also appointed members then. And the people will have queries. So in abolishing the appointed seats, you have to give a clearer label or name to the ex officio members. Under Secretary, regards the names, a change of name will not change the fact that these district councillors are governed by regulation or law. As to whether we should change the names, we should go about discussion first, because we have different views in the community on whether we should abolish the ex officio seats and whether we should go for further discussion. Now, our focus here is on the abolition of appointed seats. So we should narrow down the discussion on this matter. For other issues, we haven't gone through consultation or in-depth discussion, so we should not discuss these matters here. Do you think it is a good opportunity for us to discuss this at this meeting? Because at the end, you may have to go for consultation on the change of name. And we'll have to wait for 2 or 3 more years before a further amendment. So I wonder if it is a good opportunity for us to discuss the change of names here. I think Mr. Leung thinks that the ex officio members also have a seat. And even in LegCo, we have ex officio members. And these people have a seat in the council. Say, for example, in LegCo. And they have a seat because there is a channel for them to have a seat. I don't think the matter is necessarily a negative one. And they came from the election of the Rural Committee. And they are special. They are different from the members who are directly elected. Well, so I think it's worthwhile for us to discuss whether they should be given a different name. Ms. Alice Mack. Chairman, I quite agree with you. I think we should focus on the appointed seats or members. For the rural community members, they may not necessarily come from indirect elections. And if we change the name of these ex officio members, we may have to see whether the elections of rural communities should be changed. Maybe the RC members in the future will be elected by all villagers in the village. Then the members elected will not be from the indirect elections then. So I don't think the ex officio members are necessarily from indirect elections. Of course, they are from RC elections. But the naming is rather tricky because they are from RC and they are really ex officio members. So in the future, maybe people who are good in Chinese and English can help us out here. Now, coming back to our discussion, it's rather simple. I don't understand why we have to have an open public meeting or hearing, because in the community, people agree we should abolish the appointed seats, and so does the government. Then we should simply go for the abolition. And our focus should be here. For the side matters, they should be further discussed. Because for the ex officio members issue is related to the RC elections. In abolishing the appointed seats, we should not disregard the contribution made by appointed members. I'm not sure whether members have similar experience. I was an appointed member and then I got a seat from direct elections. So some appointed members do get support from the public, and some appointed members later also gone through direct elections. So you should not disregard their contribution on the district level. I think we can simply look at the amendment. As for the composition of DC, we may reserve the discussion for the future. I agree with Ms. Mack. Yes, we propose to abolish the appointed seats. But appointed members gave professional advice, they contribute financially, and they also put in lots of effort on the district level. And now, because of our development, we will abolish the appointed seats. But in doing so, we are not disregarding their contribution. As for the names, we spent several minutes on this. And it's very clear from our discussion that it's not so simple that it's about the naming. Rather, it involves the elections and whether they should be kept, because it's so complicated. So I don't think this is the right occasion for us to discuss these aside matters. Mr. Kenneth Chen. Well, the scope of the issue is quite narrow and rather focused. We are talking about the abolition of appointed seats, and we welcome views on method of election and the names, titles of the members. Perhaps these views can be passed on to the relevant panels. For example, the HA panel, HAB, where it's appropriate for us to discuss the other side issues. Now, for this bill, I have some questions. This is not the first time we try to abolish appointed seats. In fact, before the handover under Governor Chris Patten, this already happened. So is it the case that we simply have to remove all the references to appointed seats in the ordinance? I see that, however, there should be some amendments to the relevant provisions too. That is outside the scope of DCO. So I have the following question. Some appointed district councillors may be appointed to other organizations under relevant regulation. For example, some appointed district councillors, have some of them become the CE election committee? The answer is no. And well, if there is such a case, then do we have to go about certain changes? That is, some appointed district councillors are appointed to other organizations. And after the bill came into effect on the 1st of January 2016, will there be any changes to the roles of these district councillors? Under Secretary, thank you, Mr. Kenneth Chan, for raising this point to see whether we have left anything outside the DCO. May I defer to colleagues from DOJ? Ms. Wong, about provisions or references to appointed seats in other ordinances. In Part 3 of the bill, this matter has been dealt with. That is, the references to appointed seats in other ordinances. So Part 3 already deals with this matter. The previous abolition of such seats happened in 1993, and the mode or the method was the same. That is, all references to appointed seats in DCO were removed. Under Section 11(2) of DCO, the appointed members will term starts from the date he got appointed and ends when the term of DC ends. And for this bill, it will come into effect in the 5th term of DC. So the term of the appointed DC members will end at the commencement of the 5th term. So the member will complete his duty in the 4th term. All right, let me give you an example. For example, well, we have an appointed DC member who is appointed to take up other roles which goes beyond the 1st of January 2016. It may be a bit embarrassing. I'm just giving you an example. You know, there are many consultative organizations on the district level, and some appointed members are appointed into these organizations, and the term in the organization goes beyond the 1st of January 2016. What will happen? It is a bit embarrassing, but I'm simply addressing 2 points made. I'm not focusing on the people here. Yes, the member may be very competent in serving the public, but because of the change, maybe he will not be able to serve the public anymore. So that's why I say it's embarrassing. If we don't have any of such problems, then it's fine.
處理緊呢就係即係取消佢委任議席。佢
Under Secretary, yes, we have started dealing with the issues related to the abolition of the appointed members to take effect on the 1st of January 2016, and well, we are looking into matters related to memberships of such members in advisory bodies that extend beyond the 1st of January 2016. Sometimes such members are appointed into these advisory bodies in the capacity of by an persona capacity, not his capacity of an appointed member, but we will look into it. As far as I understand it from district councils, for some district bodies, say for example, for the governance bodies of hospitals, and there is an election within the district councils, and then a member is elected to join these bodies. But when the DC term finishes, the terms of membership of other bodies usually finishes as well, and very often such members do not have the right to vote. And it's already stated in the law that only directly elected members can be nominated and participate. So I don't think that is the issue of appointed members being involved. Mr. Chung, I think that for DC members, some of them may be nominated to join advisory committees or district bodies, but the term will be renewed, or a different member might be nominated to join, so there is no such problem. So for some people, they are represented by two types of members, a directly elected member and also an appointed member. I think it is unreasonable because in the urban area you are only served by one member, whereas in the rural area you are served by two members, a directly elected one and an official one. I'm not objecting to the existing of ex-official members. Perhaps in area committee you can have an indirect election to return an ex-official member. This is just to rationalize the number of seats in councils, because in rural areas constituents are served by two DC members. Under Secretary, I am sure Mr. Chung understands that ex-official members is a tradition of the new territories. They have their own historical background. And as to whether we will create new seats along the lines of thinking of Mr. Chung, I think we will have to go through detailed discussions first, and this is not a suitable platform to discuss this issue. Ms. Alice Mack, in 1993, when the appointment system was abolished, it was much simpler. At that time, appointed members, well, ex-official members was just as directly elected members. At that time, there was an electoral college as well. In 93, there was none. In 96, there was an electoral college, but not in 93. At that time, Mr. Chris Patton just abolished it as quickly as he said it. There wasn't even a bills committee. There wasn't even notification to such appointed members. It was very simple and swift. As the administration said, well, there are more ordinances that requires amendment other than the DC ordinance. Because there are references to the power of appointed members in some other ordinances, say, for example, the Electoral Affairs Commission ordinance. Appointed members will not join committees that straddle between two terms. Say, for example, a committee that deals with New Year's Eve activities, because it will straddle 2 years. So appointed members will not join such committees or bodies. I believe it will be the same in the future. Based on my experience as a DC member, whenever a chairman of a committee is elected or representative of the DC is elected, we always keep this in mind. As Mr. Chung said, whenever it comes to DC representatives, when there is a change of term, then the representative will change too. In, say, for example, consultative committees related to hospitals, even if you get re-elected, there will be a fresh round of election before one can become a representative. Well, I believe that what Mr. Lau himself was also a DC member. I believe he understands. In 1997, my understanding was that there was a bill introduced. Well, of course, Mr. Chung and Ms. Mag gave us a reminder. I think what Mr. Chen said was a reminder to ask us to look into certain issues, and we will do so. So any further discussions about areas of concern of members? If not, it seems that we're moving quite quickly. And we can go into clause by clause. And then we will have a public consultation. We will have a public hearing. Arrangements will be made. Now, let's go to clause by clause. How do we approach it? Paper number CB2, CB bracket 2860/12 to 130 bracket 01. I will now give the floor to the administration to take us through the clause by clause. Ms. Tang. We will briefly go over each clause about the objective of the deletion. First is the effective date. We propose for this to take effect on the 1st of January 2016. Yes, in relation to the effective date, any questions? Mr. Christopher Chung, 1st of January, does it mean that after that date, the appointment will discontinue? We're talking about 1st of January 2016. So what about the election of 2015? If that means, starting from the 1st of January 2016, there will no longer be an appointment system. Perhaps may I add that in the past, when we will deal with the appointment at the end of the term for the next term. So at the end of 2015, there will no longer be any appointed members. Yes, we're now looking at the blue bill. And then clause 2, interpretation. This is a technical amendment in relation to the ordinances and the relevant regulations. First, in part 1, we amend the ordinances and also some subsidiary legislations. They are consequential amendments. Any questions? Now, I think this is also rather technical. This is just a technical point. And next, part 2. About clause 3. Clause 3 is to amend section 2 of the District Council Ordinance in relation to interpretation. This refers to the definition of appointed members and also references of appointed members. Since we are abolishing the appointment system, so the relevant definition will be removed. Perhaps we will refer to the right document. There is a marked up copy. Please use the markup copy when you give your explanation so that we will be able to follow where amendments have been made. Yes, we are talking about page 1 of the marked up copy. First one is the interpretation. To delete the definition of appointed members. So this is not an amendment in itself. This is just a deletion. It's page 1 on the English version. Yes. No. Page 2. This was mentioned before because there is a reference of and appointed members, the 3 words. Well, may I add that this is section 4 of the ordinance. This is to amend the title of part 2. As you see in page 2, there is a reference of appointed members. This is a technical amendment to remove the reference of appointed members. Any questions? This is page 2. There are no questions. Page 3. Page 3. Page 3. This is to reflect changes in section 5. Clause 5. To amend section 5 of the District Council Ordinance. There are a number of areas. First, in the title, there is a reference to the number of members to be appointed to it. This will be removed. And the second part is subsection 2 of clause 5. This refers to the maximum number of members to be appointed to that council. That is the number specified in column 4 of part 1 of schedule 3 in relation to DC specified in column 2 of that part. So this will be removed. This is a consequential amendment. Okay, on page 3 you will see that in the District Council Ordinance it mentions the number of members to be appointed. This will be removed, and as a result, in subclause 2 of clause 5, it will also be removed as a result of the abolition of the appointment system. No questions. Legal advisor, if you think there is any problem, please raise it. Page 4. Page 4 reflects changes in section 6. Well, it's section 8 of the DC Ordinance. This is actually clause 6. There are references to the number of members to be appointed. This is in relation to the power given to the Chief Executive in Council in relation to the specified number of members to be elected. So since there is no longer going to be any appointed members, this reference will be removed. Now, in the past, the number of appointed members are decided by CE in Council, and the number should not exceed the maximum number. The
maximum number may be 1/3 of the DC, but it may not be amount to that many. So it's about the authority of the in council, but since we're abolishing the appointed seats, the relevant references will be removed. So this is the objective behind. All right. Let's move on to page 5. Ms. Tang. It reflects Section 7 of DCO. And it's Clause 7 of the bill and Section 9 of the DCO. For the first part, in Clause 9, references to appointed members are removed. This DC is consisted of 3 types of members: elected, appointed, and ex officio members. Since we're abolishing appointed seats, B, appointed members will be removed. Thank you. And the questions? Just to remove the words. And then Clause 10 of Section 10, elected member or appointed member taken to have resigned on becoming an ex officio member. Ms. Tang. Section 10 sets down the procedures. That is, when a member is appointed or become an ex officio member, he will be regarded as having resigned. Since we're abolishing the appointed seats, or appointed member will be removed in the title of Section 10 and also in the contents of Section 10 as well. For a directly elected member or an elected member, if you are appointed as an ex officio member, you have to first resign. And that will in turn lead to a by-election in case of an elected member, and in case of an appointed member, the government will have to appoint another member. Or any question, Mr. Christopher Chung? Will the Bureau considers it again? The appointed member will be taken away. And if we're talking about someone from an indirect election in RC, would there be any problems arising? For a directly elected member, it seems that he is in an inferior position to an ex officio member. I don't know how you can explain to others. Well, we note your point. All right, I think members are fine with it. Let's move on to page 6, section 11. Ms. Tang. We're on page 6 of the markup copy. Reflects section 8 of the ordinance to amend part 4, division 1. The entire division will be removed because division 1 deals with appointed members. For example, the number of appointed members, the eligibility, and the arrangements for accepting the seats, and the disqualification of the appointed members, and how an appointed member can resign, and when appointed member's office becomes vacant, and appointment of a substitute. Now, these are technical arrangements for appointed members. Since the bill is here to abolish the system, Division 1 of Part 4 will be removed, will be deleted. That is Section 11, 12, 13, 14, 15, and 16. They will be removed. All right, any views? Well, since we're removing the appointment system, all the arrangements concerning appointed members will no longer be useful, so all these references will be removed. Let's move on to page 9, if there's no problem. Page 9 reflects Section 10 of the Ordinance, Clause 10 of the Ordinance, that is to amend Section 7T2 of DCO, which states the procedures of a DCO or a committee not affected by vacancy or defect in membership. Subsection 2B refers to appointment of a member, an appointed member, and also subsection 4B mentions the appointed member. Or since we're removing or abolishing the system, we do not need these references. Since we no longer have any appointed members, we'll remove the references. Page 10. Ms. Tang. Section 83 of DCO will be amended, which is about the designated office, the district director for HA. A gazette, the designated officer must, within 21 days after receiving notices of acceptance lodged, will be published in the Gazette. Since we're removing the system, we'll remove the references to appointed members. Or any question? Then let's move on to Section 84. The director of HA must give notice of vacancy in the Gazette within 21 days after becoming aware of the vacancy. And since such notice will not be issued in the future, we propose to remove appointed member or in the clause. Any question? I think we have dealt with the major part. Let's move on to Schedule 2 of the DCO. Page 11 in the English version reflects Part 1, Schedule 3 of DCO. It sets out the number of elected members and appointed members. Since we propose to abolish appointed seats, references, that is the column of number of appointed members, will be deleted. Earlier on, we already explained that this can be amended by the CE in Council, and such reference in the schedule will also be deleted accordingly. It is quite simple. It's about the number of elected members and appointed members. We may hold a further discussion on elected members, but we remove the reference to appointed members. Page 12 is Form 1, Schedule 4 of DCO. Is the acceptance of office under Section 13 of appointed members. Since we're removing the entire system, the system of appointment, the form should not be kept. Right, because the form is for the acceptance of office of appointed members. All right, there's no problem. Let's move on to page 13. Right, Chairman, starting from this page, we have moved into consequential amendments. There are 3 of such amendments. I'll talk about the first 2. That is page 13 and 14. On these 2 pages, under Section 14 of DCO, it sets out under what circumstances an appointed member will lose his seat or be disqualified. If he commits offense under EAC regulation, he will be disqualified. Electoral Affairs Commission regulation of electors, LCGC, District Council Constituency, and Division 2 amendments to EAC registration, electors for LC, FC, and voters for EC subsectors. Now, if an appointed member commits offense under these regulations, he will be disqualified. Because we are now removing Section 14 of DCO, we propose to remove these relevant parts as well. Section 14 is deleted. Cap 547, Section 14 will be deleted, which is about disqualification of an appointed members. Give me a helping hand here, will you? Page 6, you find it. That is about the disqualification of an appointed member. The whole part is here. All right, in fact, I'm talking about page 6. Since we have already removed page 6, then the Section 14 will be removed as well. It's about the disqualification of an appointed member. All right, is it clear? All right, let's move on to page 15. Page 15. Pages 13 to 17 is about the removal of Section 14 of DCO. So in my brief explanation, I've already explained the rationale behind. It's rather technical. I'm not going to repeat them again.
Any questions? No? Let's move on to page 18. Page 18 in the marked up copy. This is also another consequential amendment. Basically, this is in relation to electronic transactions exclusion order. This is a consequential amendment. Under the electronic transactions exclusion, electronic transactions ordinance, certain documents may be circulated in an electronic form. An electronic signature may be accepted, but there are certain exclusions under this ordinance. What is required is that an application can be made for an actual signature or the hard copy of document, and this is in relation to Section 15, subsection 1 and 2. And in that section, it refers to the submission of a written resignation notice and a signature has to be appended. This is put in the exclusion order because a hard copy, a written form is required and not an electronic form. And since the system will be abolished, the relevant reference will have to be removed. Page 8 of the marked up copy. Section 15 of CAP 547, you will find the actual provision. There is a reference of what an appointant is supposed to do under, and this is in relation to electronic transactions. This is a technical amendment. That is, Schedules 1 and 2 are in relation to Section 15, subsections 1 and 2. Any questions? No? If there are no questions, then that's it? Yes. We're finished with the clause by clause. We've only looked at the Chinese version. I'll ask the legal advisor to follow up on the English version. As you see, they are mainly removals or deletions, so I don't think there will be any problems. So we have finished with the clause by clause. That being the case, we'll make arrangements for public hearing on the 9th of next month. Let's see what are the concerns of the public that we have not covered, and whether there are any outstanding issues that we need to discuss on. Were any other issues you would like to raise in this meeting? If not, let me remind members that the next meeting is scheduled on the 9th of April, 9 a.m. to 11. Originally, it was scheduled to last till 12. And since there aren't too many deputations or individuals who have made the indication to speak, we have shortened it. If there are no new issues raised, perhaps we will be able to complete the scrutiny of the bill in the next meeting. Any other questions? Then any other business? There is no other business, so meeting adjourned. Thank you.